Good afternoon, everybody. Today is Tuesday, May 13th, 2025. This is Irene Weisman, and I would like to do a very quick update as to recent events, as some of them are very important, okay? So the one thing that very quickly wanted to discuss, receipt notices for certain cases from USCIS. If you have submitted an application under VAWA, Violence Against Women Act, U visa or T visa, if you submitted your applications in the beginning of this year, January, February, March, basically, there is an extensive delay with the receipt notices. I just yesterday received a receipt notice for a case that I have submitted in very early February. Okay, so you can see it's about a 3-month delay in obtaining these receipt notices that been driving clients crazy, driving me crazy. But just be aware of it. If the package hasn't returned, which can also, by the way, take a little bit of time if they didn't like something and they're returning something back. But if it hasn't returned and you haven't yet received the receipt notices, I'd give it about 3 months right now on that humanitarian case. Just wait it out. And then if you haven't received it, then possibly start your inquiry with with the service center or something like that. But just be aware there is extensive delays. You use USCIS and VAWA filings submissions. Okay, so that's number one. Number two. So this just started happening this week. We're only on Tuesday, so. This is very new, and the American Immigration Lawyers Association has already confirmed this. So all cases that were administratively closed by the immigration judge, the government is going to move to place them back on calendar. Yesterday I received a notification on one of my cases that was administratively closed in 2012. Okay, that's 13 years ago. Okay, I mean, this is nuts. So let's talk about what is a case that is administratively closed. So once a person is in immigration court, okay, several things can happen, right? And several things have been happening over the last few years, but there were cases that you can win a case, okay, so the judge can grant relief, and that's how the case is closed, no appeal, and that's how the case is relief was granted, okay, and that's how the case is done, and of course that's the ideal way. Then the case can be administratively closed. What is an administratively closed case? It means that a person is still in removal proceedings, but they are not actively in front of the court. It means that the court has closed whatever processing for both parties. It's off the docket, and it's just like laying there dormant, okay, until whatever happens. So no, nothing is happening, but a person is still in removal proceedings, okay? And that's an administratively closed case, okay? The judge can terminate proceedings, okay? So nothing was granted, relief wasn't granted, but both parties agreed, and the judge said, okay, we're going to terminate. Okay, and then if the government wishes, they can start proceedings again. Okay, so that's a terminated case. Let me go back to administrative closed case. Both parties can move the court to place the case back on calendar. Okay, so you, as the respondent, can make a motion to place the case back on calendar, or Department of Homeland Security can move the court to to ask the judge to put the case back on calendar. And by the way, that is has been happening, that's what's going to happen. So they actually said that in the next 2 months or so, they're planning to do this prior to July 5th or July 7th, I think, or 9th, I forget the date, early July, that they plan on, with all the cases throughout the entire country that have been admin closed, they're making a motion to put it back on calendar. A huge impact on many people, on many cases. And by the way, once a motion like that is made, you have 10 days to oppose that motion. So if your case was administratively closed because you are seeking an alternative form of relief, for example, you're relying on USCIS to issue a decision, I don't know, your CIG application is pending, 601A is pending, I-130 is pending, okay? There's a good argument to keep that case administratively closed, but then there are other cases that have been administratively closed that, back in 2012, when we first got prosecutorial discretion, many cases were administratively closed just because. I mean, sometimes we didn't even have a say in it. That they just admin closed them, and that's it. And those are, you don't even have an argument as to why, you want to keep it off the active calendar. So if you are a person and your case in immigration court is administratively closed, reach out to your attorney, because you need to strategize as to what it is you're going to do and how you are going to further proceed, okay, with defending your case, because it's going back on the docket, chances are. Well, I mean, it looks like they're planning on moving on, with all cases that have been administratively closed, okay? So that's what I wanted to talk about today. Just very brief, very important news. Hopefully the news gets around, and if you are in fact impacted, then you'll know what to do. Okay? Have a good day, everybody. Okay? Bye.